We've just heard the judgment by the High Court in Johannesburg. As Ace Magashule, the suspended ANC Secretary General, had applied to the court to ask the court to set aside the step-aside resolution that was adopted in its conference in 2017. This follows, Ace Magashule's brush with the law, and as the ANC step-aside resolution, admits that, all parties, or rather all party members who are found to have been on the wrong side of the law need to step aside as the party deals with them. We'll be joined in a moment by Sanusha Naidu and as well as Angelo, Fick, a political analyst, to help us make sense and analyze this matter in greater detail. This is the agenda on SABC News. Also making headlines this morning is that, the case of Jacob Zuma's application to stay the arrest order at the Pietermaritzburg High Court will be heard in a moment, and we'll be crossing to our reporters there to make us help us understand what the implications of that is. And our analysts are now back on the line, and I'll start with you, Sanusha. A very good morning to you and a warm welcome to the agenda. What do you make of the judgment that was delivered short while ago?
Good morning, Samphira, and to Angelo and the viewers. I think it was a judgment that kind of gives a very serious reflection in terms of the internal dynamics of the party, the fact that it provided clarity around the suspension rule. And I think more importantly, I found the concluding remarks by Judge Colopin very important in terms of the fact that they are limited in how much they can pronounce on the internal processes of the party. Now, we do know that this judgment has a lot of implications in terms of where things are, both internally and also within the body politic of the state. But I think what it does do is it sets into clarity the fact that the courts, while they can arbitrate on these particular issues, they don't want to get too caught up in the messy details. And I think the last remarks made by the judge and in the judgment itself, in terms of its kind of limited arbitration in terms of the internal matters, and the fact that the institution or the organization is a voluntary organization, that members go into that organization knowing full well what the rules are, what the dynamics are, and what the institutional architecture is, particularly in terms of the alignment of the ANC constitution to the national constitution, is very important. Because I think what we were seeing with this judgment, and I think also in other kinds of judgments that possibly would have been thought of, but now we have to think about it much more critically, is whether or not the members in the party, when feeling aggrieved, can turn to the courts and try and use the courts to litigate against each other in terms of political opponents. And I think this is what this judgment does in that way. Now, this is, again, very open to interpretation. I suspect that the legal team of Ace Magashule will take this on appeal. They may find another avenue, but it doesn't bode well for them, because I think, again, the courts are very aware that in terms of the internal dynamics in the party, it's something that they don't want to stray too much into the ANC lane.
Was a legal or a political fight? I mean, we can't turn our backs on the dynamics and the complexion of this particular case. Do you think it was political or simply legal?
I don't think anything is only legal. I think the undertones of what we saw and what we have been seeing in the last several weeks and months and whatever is the fact that there's a political connotation to these things. The fact of the matter is the pronouncements that were made around checking to see whether Rule 25.70 was legal, was it justified. I mean, it had political connotations, so you can't ignore it. And I think that when you start using the courts to fight out these political battles, then, of course, the courts get nervous. And I think in this case, the courts realize that in the context of what was happening, I mean, the entire application has been dismissed. And even the fact of whether or not Mr. Ace Magashule could institute his own kind of suspension letter, again, the courts were very clear about that. The judgment was very clear about that. That in that context, there was no legal criminal offense that President Ramaphosa had in terms of being instituted against him. So I think here again, the gray area between the political and the legal, I get very nervous about that, because I think that I'm not a legal expert, but once you start going to the courts to fight out your political battles, then of course you keep that the rule of law has to be maintained, but then you don't want that to become a complex set of issues, because that is where you want to fight out your political battles if you can't deal with it in the party.
Now, Angelo, I want to take you up on that as well, and welcome to the show. Thank you so much for joining us. I mean, what are your thoughts and your reflections on the outcome of this case? Do you think that it was illegal or it became even more political?
Well, what I think it allowed for was the subsuming of the political under the legal. That the reminder, as Sanusha points out, that just because you're a voluntary association doesn't mean that your internal rules can be in conflict with the law, the legal framework of the country, or particularly the foundational law. And in examining the ANC's rules and regulations, the court found that they were indeed within the framework of both the common law of natural law and natural justice, as well as the foundation law of the country, the constitution. But these implications reverberate beyond the particular issue of the ANC to other political parties and to people who are disaffected with their political party belonging. That voluntary associations are voluntary associations, and that when such associations, unlike employment situations, begin to conflict with your beliefs or your practices, you are free to leave them as you are free to join them. And that when you join them, you sign up to their rules and regulations and agree to abide by them, and therefore cannot then leave that voluntary association and call upon the law to fight your battle for you. And this, I think, has very important consequences in the South African political landscape, and could be read preemptively, I think, in relation to people being able to stand as independent candidates in national elections as of 2024, because it then means that you are not beholden to political parties, but can represent, if you wish, to your constituents much more directly without having to abide by the strictures of a voluntary association such as a political party.
Now, Sanusha, I do understand that you have to go, and unfortunately, I have to let you go. But thank you so much for joining us and for sharing your thoughts and reflections on this matter with us. Thank you.
Thank you so much, Samphira.